So we've discussed the agreement, element 1 of a contract, which constitutes having an offer and an acceptance. The next essential element to a contract is consideration. A promise is not recognized or enforced as contractual unless there's consideration that has been given. So what is consideration? Consideration is the value that's given in return for a promise, i.e. bilateral contract, or performance, a unilateral contract. Let me give you this for example. I promise to give you a share of the profits. I promise to clean the office. I promise to give you $500 because you're my favorite student. Are these contracts? No, they're not contracts. What's it missing? It's missing your stake in the game. There has to be value given in return for a promise or a performance. A purely gratuitous promise, one that is not quote unquote paid for in some way, cannot be enforced as a contract. So if I sell you my car for $1,000, what's the stake? I give you my car and you give me $1,000. Your stake is $1,000, but you're getting a car. My stake is I'm giving you a car, but I'm getting $1,000. So if it's purely gratuitous, something that's not paid for, it cannot be enforced as a contract. Now there are two parts to consideration. Two parts that we got to consider for consideration. Something of legally sufficient value must be given in exchange for the promise, and it has to be bargained for. There has to be a bargain for exchange. So let's start with the legally sufficient value. What does that mean? Consideration must be something value in the eyes of the law. And it may consist of a promise to do something that one has no prior legal duty to do, like for example, to pay on a receipt of goods. Performance, the performance of an action that one is otherwise not obligated to undertake, such as providing accounting services. And refraining, or forbearance. Refraining from an action that one has a legal right to undertake is called forbearance. So any type of one of these three things would be considered consideration, or of something of value in the eyes of the law. Consider this example. Following his 300th nosedive into the snow, Alpine has become frustrated with the sport of skiing. He decides to give his skis to his friend Buster Legg and promises to drop them off at Buster's house as soon as he gets out of the hospital. What do you think of that example? Is that a valid contract? If Al changes his mind and fails to deliver the skis, can Buster sue? No. This is purely gratuitous. Buster can sulk and pout and have a massive tantrum, but he has no legal recourse. He cannot sue Alpine. Consider this. Al agrees to sell the skis to Buster for $100. That's their market value. Buster pays the $100 immediately, and Al agrees to deliver the skis once he is out of the hospital. Is there a contract? Yes, there is. What's the consideration? What's the value exchanged here? Al gets $100. Buster gets skis. So they each have a stake in the game. So Al would have to deliver those skis once he's out of the hospital. If he does not, Buster will have recourse to sue. And what could he sue for? He could sue for his $100 back. Common law. Under common law. Damages under common law. Or what else? He can sue to ask the court to make Al deliver those skis. And what's that found under? Equity law. So legal sufficiency. There has to be some legally sufficient value exchange. Bargain for exchange is our second component for consideration, what I like to call the inducement. This is the consideration provides the basis for the bargain struck between the contracting parties. So the parties must have agreed to the exchange or the promises. So its consideration provides the basis for the bargain struck between the contracting parties. Parties must have agreed to an exchange of the promise. Each is inducing the other. So it distinguishes from the gifts that we were talking about, where I agree to share in the profits with you. There's nothing bargained for or exchanged. Like the example with just before this with the skis and the $100. There's a bargain for discussion and there's an exchange. $100 for skis. What about adequacy of consideration? What's the difference from legal sufficiency? Legal sufficiency, something of value in the eyes of the law. Adequacy, what does that refer to? Quote unquote, how much consideration is given, or the fairness of the bargain? Do we care about that? Do we care who's getting what? General rule is courts are not concerned with the adequacy of consideration. So Al sells his skis valued at $100 to Buster for $500. Buster pays the $500 and later learns that they're only worth $100. Can Buster sue? No, Buster cannot sue, unfortunately. He may have made a bad arrangement, but he cannot sue. Courts are not concerned with adequacy of consideration. They believe that people are free to bargain as they wish. If people could sue because they entered into an unwise contract, courts would be very much overloaded. How about Al agrees to sell his skis to Buster for $100 cash? Plus Buster promises to stop smoking. Is this a valid contract? Al agrees to sell his skis to Buster for $100 cash, and the extra that Buster has to promise to stop smoking. Yes, that would be a valid contract, because courts do not care about the adequacy of consideration. We do not care that Buster gave up more than Al. Sometimes one of the parties, or both of the parties, to an agreement may think that consideration has been exchanged when in fact it hasn't. And we have this concept called the pre-existing duty rule. What if you already had a legal duty to do something or forbear from doing something? How does that work? The performance of or promise to perform a pre-existing duty is not consideration. So how does it arise? It can arise two ways. One, by law, a law requiring that somebody already has a duty, or there's already an existing contract. How does this work? Consider this example. Sheriff cannot collect a reward for information leading to the capture of a criminal if the sheriff already has a legal duty to capture a criminal. That makes sense. Pre-existing duty. He already has a job to find criminals. We're not going to pay him a reward on top of doing that. How about this example? Alpine owns a ski lodge. He entered into a contract with Buster Legg under which he sold the lodge to Buster Legg for $400,000. Before the sale closed, Al realized that he had underpriced the lodge, which is worth at least $450,000. He approached Buster and asked him to agree to change the price to $450,000. Buster believed that he did underpay and felt that the lodge was still a good buy at $450,000. Not wishing to take advantage of Al's mistake, Buster agreed to pay the extra amount, amending the prior relationship. So is this let's talk about the first portion. Is the first portion of this a contract? Is that a valid contract? They enter into the contract to buy the lodge for $400,000. Yes, that's a valid contract. The modification, which comes next, where Al approaches Buster about changing the price to $450,000 and Buster agrees. Is that a valid contract? Or a modification to the contract? That is not. Why? because there's no consideration. If you modify an original contract, you need additional consideration or separate consideration. There needs to be a separate consideration from the consideration given under the original contract. So you can modify the original contract, but what you need is additional consideration. If you already have a pre-existing duty, an obligation under a contract, then you can't use the original consideration in that existing contract as a modification to another contract. So what makes this, what's the failed consideration here, right? Al did not give any consideration to Buster for his promise to pay more, because that's what happened here. Buster agreed to pay more, but Al wasn't out anything else, and he is going to gain an extra $50,000. So pre-existing duty existed for Al to transfer the lodge for $400,000. Buster does not have to honor the extra $50,000. Consider this. Can you ever modify a contract? Yes. I just kind of went through that when there's a new agreement and you have to have additional consideration. Al agrees to include a snowplow in exchange for $50,000, the $50,000. So it's the same example as the one before, except Al agrees to include a snowplow and Buster agrees to pay the $450,000. Is this a valid modification? Yes, it would be. Why? Because consideration exists. There's a bargain for exchanged. Al is thrown in a snowplow, and Buster is paying the extra $50,000. Does it matter that the snowplow might be worth less than $50,000? Maybe it's worth $10,000? No, because the court doesn't care about the adequacy of consideration. So this is a valid modification agreement because there's separate consideration from the consideration given under the original contract. Why this rule? Why this rule that in order to modify an existing contract, there must be separate consideration from the original contract? Why? It prevents coercion from modifications. Consider a contractor who agrees to build your house for $100,000. They're 1 month into the project and you're told they need an extra $50,000 to finish. You can't find another contractor to complete the project, so you agree to pay it. When they come collect, you refuse. That's coercion. How about a contract with a cab driver to take you to a hotel from the airport? He agrees to accept $85. Halfway through the trip, he stops and says, oh, $100, I drop you off here, right? Of course, you agree to pay the extra. You want to get back to your hotel, but this is the reason why you need extra consideration or additional consideration for modifications. But there are exceptions to the rules. There's always exception to the rules. Can contracts ever be modified? Sure. Baxter Construction contracts with Kant to build a house for $100,000. In digging for the foundation, Baxter finds an underground tank full of hazardous waste. Baxter advised Kant that it needs an additional $50,000 to adequately get rid of the hazardous waste and cover cleanup. Now, there was an original contract to buy the house for $100,000. And now Baxter wants an additional $50,000. Do we see any difference in this than in the case involving Alpine and the lodge? Maybe this underground tank full of hazardous waste that nobody expected to be there or didn't know was there. So if there's difficulty in performing, contract may be modified without separate consideration if a party encounters extraordinary difficulties that were unforeseen at the time the contract was entered into. So while there might be extraordinary difficulties that they encounter, but they have to be unforeseen at the time the contract was made. And in that example, would encountering an underground hazardous waste tank be something that is foreseeable and entering into the contract? So maybe, maybe not. Depends on more of the circumstances. That's one of the things the courts would consider. But this is a common example of where a modification may be allowed in circumstances, as long as it's unforeseen at the time the contract was entered. Another example where a contract can be modified: rescission and a new contract. Parties are free to agree to rescind their contract. They're free to do that. Their contract must be, but their contract must be in an executory fashion. What does that mean? We learned that in Intro to Contracts. It still needs to be carried out. You can't rescind a contract that's been fully performed. So it has to be in the stages that it hasn't been carried out to the full extent. Rescission by definition is the unmaking of a contract so as to return the parties to the positions they had before the contract was made. Can they make a new contract? Of course they can. So a court may never see this where parties had an original agreement, like Alpine and Buster. In that situation, they could have agreed to rescind their contract and then start anew. That's a problem. It's hard to determine whether there was consideration for the new contract or whether the parties had a pre-existing duty. But in any event, parties are free to say, you know what, let's give up on this contract, let's start fresh and new. But both of them would have to agree to do that. And then they can either go their own ways or they can enter into a new contract. All right, let's consider, I like saying that, let's consider past consideration. So Elsie is a real estate agent. Elsie, a real estate agent, does her friend Judy a favor by selling Judy's house and not charging a sales commission. Later, Judy says to Elsie, in return for your generous favor, I will pay you $1,000. If Judy doesn't pay, can Elsie enforce or sue her friend for $1,000? Is this a contract? Is there consideration? What is the consideration? Because she sold her house, but she did it as a favor. And later, Judy's agreeing to pay $1,000. So Judy's promise is made in return for past consideration, and that's considered a gift. Due to lack of consideration, it's unenforceable. Promises made in return for actions or events that have already taken place are unenforceable. Why? Because it lacks consideration. But what component is missing? The bargain for exchange. It's missing the bargain for exchange. You can agree or bargain for something to take place now or in the future, but not for something that's already taken place. Problems with consideration. Types of problems. When consideration consists of the exchange of mutual promises, the undertakings on both sides must be real and meaningful. So if the promise of one party has qualifications or limitations so strong that they negate it, it is really no commitment at all. Because it does not bind the party at all, this is lack of consideration, and it voids the apparent contract so that neither party is bound. So we have, let me back up a moment. We have three categories of problems that consist with consideration: illusory promises, settlement of claims, and promissory estoppel. I'm going to go through each one of these separately, and I've already kind of started with the illusory promises. So when consideration for an illusory promise, both parties must be bound or neither party is bound. That's what you have to consider. When the consideration consists of an exchange of mutual promises, the undertaking on both sides must be real and meaningful. So if the promise of one party has limitations that are so strong that it negates it, there's really no commitment at all. So in this example, Buster promises to buy Al skis for $100 and Al promises to sell them to Buster unless Al changes his mind. Is that real and meaningful? No, it gives Al an out, right? There's no bargain for exchange here. It's either both parties must be bound or neither. Abe contracts to hire Chris for 1 year at $5,000 a month, reserving the right to cancel the contract at any time. Again, are both parties bound here? No. Disqualification on both of these reserves the unlimited discretion of Al in the first case and Chris in the second case. So while they both might think that they're being clever into getting people to make promises, their lack of commitment removes the binding force from promises from Buster and for Abe. Settlement of claims. That's another area where consideration is kind of, so there's some wiggle room with consideration. I'm going to give you this term. It's called accord and satisfaction. You do not need to know it for purposes of consideration. We'll learn that later in the semester when we're talking about debtor-creditor relationships. But it is it's a common means for settling legal claims. In this particular instance, it's when one person owes a debt to another and offers a lesser amount that's owed to resolve the case, to resolve it. So, for example, actually, it's kind of like the pre-existing duty rule where creditors agree to accept less from a debtor than what is owed, and then claiming that they're not bound by consideration. So let's kind of go through this so you can see what I mean about the settlement of claims in relationship to consideration. Okay, you borrow $20,000 from me. I'm a creditor, and you're the debtor in that relationship. You come to me and say, I can't pay you $20,000. Will you take $10,000? I say, sure. And I'm still entitled. So the question is, am I still entitled to the other 10? Can I sue you for breach of contract for the additional 10? You wanted me to take 10 to resolve the 20 that's owed. In this case, I say, sure. Am I still entitled to the other 10? Yes, I am in this case because I'm not bound. Why? Because of consideration. There's no consideration for me to enter into. The agreement was you owe me 20. You're going to pay me 20. The fact that you came and say, hey, will you take less for 10 does not absolve you of the fact that you still owe me another 10 and I can still sue you for that. That's if we agree that you owe me $20,000. Okay? Rules kind of change a little bit where the debt is in dispute. So, owe the contractor $20,000. You send a check for $12,000 and write on the bottom in the memo section, in full satisfaction of the amount owed on the check. Contractor cashes the check. Months later, contractor sends you a letter seeking $8,000 for the balance. You refuse, saying, by cashing my check, you agree to take less. The contractor sues. Is he entitled? Yes, he's entitled to sue you for the balance of $8,000. The same example before with regards to there's no consideration. Despite the fact you write on the bottom of your check, this is in full satisfaction, that's not acknowledgement. Silence is not acceptance. Okay? So I wanted to note this example here because this seems to be a common mistake with folks in general. This is a common thing I run into with my practice. So let's say, I want to go back, actually let's stay with this example. So let's say you owe the contractor $20,000 and you send a check for 12. So now you owe 8 and he sues you for 8. Okay? This is where we get into the accord and satisfaction. Okay? But now you're in court and you say, I don't owe you 8. We didn't agree to 8. You're tacking on interest. Whatever the issue may be, you dispute that you don't owe 8. Maybe by your calculation, you owe 7. Or let's say 6. But you owe less than 8. Okay? So then you go to the contractor and say, look, you say I owe you 8. By my calculation, I think I owe 7, or I owe 6. So why don't I pay you 7 and we call it even? Now is that okay? It still deals with the amount that's owed, initially agreed to. In this example, if the dispute is over the amount owed and there's a settlement reached for less, there is consideration here. What are they giving up? They're giving up their respective claims. Of one saying, I only owe 6, well, I only owe 8. They're giving up their claims and resolving the issue. And that's called an accord and satisfaction. And you don't need to know that right here, right now. What I'm showing is that what the consideration is. So when you see that happening, it's usually because there's a dispute over the debt. When there's no dispute over a debt, yeah, sometimes people just agree to get it done and over with and have some money rather than spend the money to go through court. But in reality, there needs to be a dispute in the amount that's owed in order for there to be valid consideration to take the lesser amount. We also have these two concepts, release of liability and covenant not to sue. Both of these types of agreements, they're recognized, but there has to be some consideration. A release of liability, what is that? An agreement where one party gives up a right to pursue a claim against another party. And there's always, in this example, there's always a consideration that is given. Like the example we just did, what would happen is in exchange for the payment of money, there would also be a release not to sue, or the release of liability. We're going to talk more about these specific types of contracts later on, so I don't want you to get bogged down by them. I'm just trying to show you examples relative to where consideration is relative to these. So covenant not to sue, what's the difference? Covenant not to sue is different. It's the release is a waiver of or relinquishment of a known right. You have a right. You have a right to sue, but you're being released from that liability. Covenant not to sue, on the other hand, is preserving the existence. You know you have this right to sue, but you might do something else with it. You might not. You might agree not to sue. That might not be super clear right now because I don't want you to get bogged down by it. In either event where you agree not to sue somebody, covenant not to sue, or you release someone from their liability, their sum has to be a bargain for exchange and must have consideration. You just can't release it willy-nilly, if that makes sense. If that doesn't make sense, shoot me out a question and I'll try and clarify that. But these are going to be agreements that we're going to come up with later on, we're going to deal with later on in the semester. They must have consideration. And then we have the concept of promissory estoppel. We're going to hit this term a lot. I think we've already looked at it twice. Bailey, the owner of a local machine shop, employs 6 employees. As part of their employment, Bailey orally promises to pay each of them $2,000 per month for the remainder of their lives after they retire. Sale, one of the employees, retires. He receives $2,000 a month for 2 years, but after Bailey stops paying, can Sale sue to enforce the promise? So, do we have a contract? Is there consideration? It's kind of like a gift, right? As part of the employment, Bailey orally promises to pay each of them $2,000 per month for the remainder of their lives after retirement. They get their paycheck. Is this a gift? Can Sale enforce that promise? Isn't it kind of like sharing in the profits? In some instances, we have this promissory estoppel. When individuals rely on a promise and such reliance may form a basis of contract rights, that's promissory estoppel. When individuals rely on promises and such reliances may form a basis for contract or rights and duties. So is there some reliance here? If someone has relied on a promise, and in this instance, Sale, Bailey might be barred from revoking that promise, even if there is no consideration. And these are the 4 things that a court is going to look at. Was it clear? Was the promise clear and definite? Pretty much was in that example. The promisee must justifiably rely on the promise. Sale did. He retired and he received payments for 2 years. Reliance normally must be of a substantial and definite character. Well, in this instance it was, due to the fact that he retired and was receiving the money and relying on it. And justice will be better served by the enforcement of the promise. What else would Sale be able to get? But what recourse could Sale get otherwise? A big, large payout? Who knows how long he would live and how much that would be. So, in this instance, this is going to be, this would be an equity, where the court orders Bailey to keep paying $2,000 a month, because I believe all those factors are met. And this is hard to meet. But it, in some circumstances, if there's a contract that has no consideration, but a promisee relies on that promise and all of these elements are met, the promisor might be held liable. One more example on promissory estoppel. Faith Reliance owns a motorcycle, which she has kept comprehensively insured. However, she recently lost her job and cannot afford to pay the insurance premium that's due on August 1st. On July 20th, she asked her father to help her by paying the premium. He agreed and took the policy renewal notice from her, promising to pay it the next day. Sadly, it is well known in the family that Faith's father is a big talker, and basically he never does what he promises to do. And true to form, he did not pay the premium on July 21st, and Faith received a final warning from the insurer on July 25th that the policy would lapse if the premium wasn't paid by August 1st. When she showed it to her father, he apologized for forgetting to pay it and assured her that he would mail the check to the insurer the next morning. Hearing nothing further from the insurer, Faith assumed that matters had been taken care of. A couple of weeks later, the bike was stolen. Faith then discovered that her father never paid the premium. Can Faith recover anything from her father? If so, what's she entitled to? Is there a contract? Well, there's not a contract because there's what's missing? Consideration. So what would be her claim? That Dad has to pay for the loss of the bike? Probably. Are there clear and definite promise? Yeah, on two occasions. She rely on it? She sure did. Its reliance normally must be of substantial and definite character, and I would say so in this case. And will justice be better served by the enforcement of the promise? Well, how else is she going to get her bike back? She doesn't have any insurance that her father said that she would pay for. So I believe that she would be able to claim the recovery of what's owed for her bike from her father. So that's how promissory estoppel works. How about this example? In consideration of the fact that you are my favorite student, I will pay you $100. Is this a valid contract? No, this is just a gift. But I said in consideration. That's not really going to matter. So if you can't use the words alone to create consideration by saying in consideration of, so this is just a gift, and that's consideration. So we've covered offer, acceptance, and consideration. The next two topics will be capacity and the legalities of a contract.